Hi, very good morning. This is an income tax judgment, a very interesting judgment. Issue is whether the assessing officer must give an opportunity of hearing before passing the assessment order. That was the issue. The judgment is of the Allahabad High Court. In this case, what happened was ex parte assessment order was passed without giving opportunity of hearing to the taxpayer. So taxpayer filed a writ petition challenging the assessment order. 2 3 dates you have to note down. Note even you can. It is not necessary. You should note down. Take just note of it. Notice was issued on 11/3/2024. Date of hearing was fixed on 15/3. For some reason, the taxpayer was not able to appear on that day. But he gave the adjournment letter on 16/3/2024. That is the next day. 15/3 was the last date, a date of hearing. The taxpayer went on 16/3 and submitted an adjournment application. AO immediately fixed the date of hearing on 17/3. I don't know whether the AO knows this or not. It was a Sunday. How the AO fixed 17/3, it is anybody's guess. Then AO passed the order on 23/3/2024 without giving any opportunity of hearing. So this was challenged, the assessment order was challenged by the petitioner, the taxpayer. The government council submitted, there is an effective alternative remedy. So the writ petition should not be admitted, it should be thrown out. That was the submission of the government council. Further, the council submitted, the petitioner was not cooperating with the assessing officer and hence the order was passed. This was the submission of the government council. High Court held that section 144B contemplates opportunity of hearing to the taxpayer after issue of show cause notice. If taxpayer requests for opportunity of personal hearing, the same has to be given. Reading the provisions suggests that grant of opportunity of personal hearing is not optional at the discretion of the AO. Providing opportunity of hearing is a rule, and its waiver is an exception to be exercised by the taxpayer. The court says the provision cannot be interpreted to mean that opportunity of personal hearing may be granted only where the taxpayer specifically requests for the same in writing. That is not the issue. Whether he asks for it or not, you must give an opportunity of hearing, personal opportunity of hearing. The submission of the department counsel was that the taxpayer participates in the proceeding by way of a written reply. So, if the taxpayer seeks to avail opportunity of hearing, he must specifically ask for it. That is the submission of the government counsel. The court did not accept the above submission. The court held that by submitting written explanation, facts and law may not become clear on their own. Very, very interesting observation made by the Allahabad High Court. The facts and explanation therein are required to be pleaded and are necessarily to be explained. It is not uncommon that in the course of judicial or quasi-judicial proceedings, the written document may be read in more than one way. That is also true of all explanations and replies. Also, language and writing are a mode of communication. It varies from person to person. Often, same and similar thoughts are expressed differently by different persons, depending upon their own skill and preferred use of expressions and method of writing. Therefore, what may be intended to be communicated by the taxpayer may be received differently by the AO. Normally, it is the case. You write some reply, the AO understands that reply in his own way, and then he passes the order without understanding what you are trying to communicate. So that is why a personal opportunity of hearing is given even in the courts, High Court or any court you take. They give personal opportunity of hearing so that you will explain what is written in the reply. The court said, Allahabad court said, for the purpose of an effective discussion to arise and a reasoned conclusion to be drawn by AO, oral hearing remains an important and near about mandatory requirement to pass a just and proper judicial or quasi-judicial order, and also to preserve the faith in the adjudicatory authorities. Further, the court said, this is also a very, very interesting observation and interesting point. The court says the first appellate authority may either confirm, reduce, enhance, or annul an assessment order. They cannot remit the matter back to AO. It cannot be sent back. When you file an appeal, now the power of remitting the matter to the assessing officer has been removed. In the absence of such a power, then the appellate authority has to take up the job of making the assessment, which is not under the scheme of the Income Tax Act. If opportunity of hearing is not given, then such situations are bound to arise. In any case, the taxpayer would have lost one opportunity for no fault on his part. Therefore, the court interpreted the word request used under section 144B will only imply if the AO is willing to accept the reply to the notice, whatever notice he has issued and the reply has been filed. Suppose if he is willing to accept, then there is no need for giving an opportunity of personal hearing. If, on the other hand, AO is not willing to accept the reply and pass a negative order against the taxpayer, then the AO has to fix a date of personal hearing and communicate the same to the taxpayer. Thereafter, it would be for the taxpayer to avail that opportunity or not. In case if he is not availing the opportunity, AO can proceed and pass the order. So, what the court ultimately says is, once a notice is issued, then it is incumbent on the AO. It is mandatory on the part of the AO to give a personal opportunity of hearing. He must give. There is no choice for him. The choice is only given to the taxpayer. He may avail the opportunity, he may not avail the opportunity. That is a different matter. But the AO has to give. That is the sum and substance of this judgment. Hope this judgment is taken in the right spirit and followed by all the assessing officers. Finally, the Allahabad High Court directed the order to be treated as a show cause notice and directed the AO to give an opportunity to the taxpayer and then and an opportunity of hearing and then proceed with the matter. Thank you very much.